giving you a few definitional clarifications. When I say mass claims, I mean cases which have a very high number of individuals. I won't put a marker on when that threshold is crossed, but it's a case which has, let's say, over 100 investors. Then there are multi-party arbitrations, a term that I'll be using frequently. And this is a kind of arbitration that involves multiple investors bringing a case against one state. And finally, you'll hear me talk about specific consent. And when I use that term, I'd be referring to consent that states must give for such kind of multi-party arbitrations to be heard by tribunals. Now, with that sort of definitional clarification, allow me to set the stage. I think it's fair to say that at least in investment arbitration, and this is the topic that I'll be dealing with, this issue arrived on the scene in 2011 when the jurisdictional decision in Arbitration versus Argentina was rendered. Why the noise, you'll ask? Well, never before had 180,000 investors banded together to sue a state. So the implications of that were uncharted territory. To add to this, the dissenting arbitrator in the case, Professor Abisab, issued a scathing dissenting opinion, faulting the majority for getting it conceptually wrong. Naturally, the decision piqued interest. Investors saw it as a new opportunity. States saw it as a new problem with investment arbitration. And academics like us just had a new issue to write about. But then you'll ask, why are we still talking about arbitration? It's been a decade. And that's a fair question. The reason we're still talking arbitration is because it brought to light two issues that have transcended that decision. The first of those issues, for the sake of convenience, I'll call a jurisdictional issue. That issue is properly divided into two parts. The first part goes to multi-party arbitrations more broadly, and the question there is, do we need specific consent for multi-party arbitrations? Or is multi-party arbitration something that does not raise concerns of jurisdiction? And the second part of that jurisdictional issue is whether mass claims are such a unique subset of multi-party arbitrations that they create their own set of jurisdictional concerns. The second issue that arose out of arbitration was a more procedural issue. This issue concerned whether mass arbitrations require a complete procedural overhaul of arbitration rules as we currently know them. Now, it's fair to say that the second issue is a less interesting one. Since arbitration, we've seen one other claim that can be called a mass claim, and this is the Cyprus case. So the question of procedural overhaul is not one that should be giving us sleepless nights. But it's the first issue, the jurisdictional issue, that I want to talk about today. And since arbitration, at my last count at least, there have been at least 10 decisions that have dealt with objections regarding a tribunal's jurisdiction to hear a claim brought by multiple investors against a state, to hear claims that are multi-party. With that sort of long background, let me briefly outline the structure of this lecture. As Ibrahim told you, the lecture is divided in two parts. In the first part, I'll attempt to dispel the idea that mass claims are a creature of their own, distinct from other multi-party arbitrations, and one that raise their own set of jurisdictional concerns. In the second part of the lecture, I'll then make few remarks about the problem of casting the issue of multi-party arbitration as one of consent. So the first part, is mass claim a beast of its own, one that should give rise to its own jurisdictional concern? Now that question really boils down to a simple fact. When we use the term mass claims, are we using it in a descriptive sense just to indicate the high number of claimants? Or are we equating it to some kind of atypical proceedings that us arbitration lawyers are not familiar with? And the source of all of that confusion originated in the decision in arbitration itself. The term was coined in arbitration Let me just share my screen over here for a quote from that decision. As you'll see on your screen, the tribunal was really using the term in a descriptive sense to indicate the high number of claimants appearing together as one mass and without any prejudgment on the procedural classification of those proceedings as a specific kind of collective proceedings. So that should end the debate right there, shouldn't it? But then that tribunal went on to muddy the waters itself by suggesting that mass claims require some sort of unique procedural techniques that are not seen in arbitrations that are more traditional and ones that are seen in representative proceedings. So it went on to say at para 48 that the proceedings it was dealing with is a hybrid kind of collective proceedings, one that involves elements of aggregate proceedings and features similar to representative proceedings. Now let's pause here and ask ourselves whether that's necessarily correct. And as I just told you at the start of this section, the question really comes down to whether we're looking at mass claims as a term that makes a quantitative distinction between arbitrations that have been started by 2, 10, maybe 50 investors, or arbitrations that have been started by hundreds or thousands of investors. Or are we really talking about arbitrations that are completely novel and distinct from these traditional arbitrations? Representative arbitrations that we've seen in the US, where an arbitration or even a court litigation is commenced by one representative plaintiff on behalf of an unknown class of plaintiffs. Here, I want to make two remarks to show that the presence of high number of claimants does not necessarily change the nature of the proceedings. The first of those remarks have to do with analogies with domestic law. Now, the idea that, as the title of this lecture suggests, that mass claims are some sort of class claims comes from objections that Argentina had raised in Arbitrat. It had variously called the proceedings class actions, representative actions, collective actions. So the comparison between class actions in the US and mass claims in Arbitrat were drawn by Argentina. So let's then look at what domestic law has to tell us. And I apologize for simplifying things here. I'm going to break down civil procedure into very simple terms. So those of you in the audience who are more proficient than me in civil procedure, please do correct me if I'm wrong. Now, in domestic courts, and the US can be credited for a lot of this jurisprudence, mass claims arise out of one of two situations. The first situation is where a single event affects a large number of claimants. Let's think of a fire in a cinema hall or a plane crash. There'll be hundreds of plaintiffs who'll be suing the cinema owner or the airline company, as the case may be. The second situation would be a situation where a dispersed set of events would affect a large number of claimants. Let's now think of prolonged exposure to asbestos. Each of the plaintiffs that will bring an action in this case would have suffered a slightly distinct injury based on, let's say, the length of their exposure to asbestos, their underlying health conditions, and so on and so forth. Now, the kind of mass claims that we're seeing in arbitration are similar to the first situation that I've just described for you. They arise out of a single state measure that affect a large number of investors. How then do domestic courts will deal with mass claims of this first kind? They do it in one of two ways. The first is the traditional way, where the plaintiffs bring a joint action against the respondent. As common law lawyers would call a joinder of parties. In the civil law, it would be something akin to a litis consortium, where a group of claimants have joined together against a respondent in such a traditional form of proceeding. There's no representative action, so to say. Each claimant brings its own claim, and the respondent gets a day against each of them. There are, of course, procedural limitations that the procedural rules impose on when such claims may be admissible. And those conditions boil down primarily to this level of similarity between the claims of each of these plaintiffs. But that doesn't take away from the principled point that I'm trying to make, which is mass claims can be heard in a traditional setting. The second procedural device that courts have come up with to deal with mass claims is the more new device of representative proceedings. Take the US class action, for example. Now, these proceedings are devised precisely to get around the rigid rules of joinder, the rigid rules requiring near identity of claims for those claims to be heard together, and also to create more efficient large scale proceedings, which may not be suited for these traditional joint actions within court systems. Now, I make all of these points to, to just show you very simply that just because of the fact that there's a claim involving hundreds of thousands of investors does not mean that you need to digress from your traditional form of procedures, whether it's in the setting of a litigation or in the setting of an arbitration. You can very well work within your traditional systems to hear a mass claim. That takes me to my second remark on whether mass claims are a beast of their own, requiring their own jurisdictional concern. And here I want to touch upon the procedural techniques that have been used by arbitral tribunals in the two mass claim cases that we have seen. And I'm going to ask whether those procedural techniques are so different from what us lawyers see in traditional arbitration that they are, in fact, not just procedural techniques, but techniques that change the nature of the arbitration at hand. Let me caveat this by saying there might eventually come a mass claim where you need a kind of procedural technique that we haven't seen in arbitration. Arbitrat considered this. For example, Arbitrat said that it might need to use a technique called sampling to decide the cases, and that technique would have involved deciding a group of claims based on the results of a sample few. Eventually, though, Arbitrat didn't use those techniques. So, if we were talking about those techniques, perhaps we could agree that they are distinct and different from the traditional forms of arbitration that we are used to. Um, but the techniques that I'm just going to highlight for you are not so very distinct and don't require mass claims to be treated as a separate kind of proceedings. I'm going to talk through three of the techniques that have been used by case law, beginning with the most obvious one, which is bifurcation of proceedings. Both Arbitrat and the more recent Cyprus case have considered that one of the necessary techniques to deal with mass claims is bifurcation of proceedings. So in Arbitrat, the proceedings was organized in three phases. The first bifurcated phase dealt with more general preliminary objections of jurisdiction and admissibility. The second phase dealt with specific objections relating to each an individual claimant and jurisdiction over their claims. And finally, the third phase in that case dealt with questions of liability and quantum. The Cyprus case is currently ongoing, but what we know so far is that the claim has been bifurcated into three phases: jurisdiction, liability, and quantum again. Now, to this audience, I don't need to belabor the point that bifurcation is neither novel nor unique. We come across it in every other arbitration. And just the mere fact that those procedural techniques are being used in mass claims as well don't change the nature of mass claims from an ordinary arbitration proceeding. Let's then look at another technique that mass claims have been using, and that's group examination of issues. Group examination of issues essentially involves clubbing together issues that have a common denominator and then deciding them en masse. These could be legal issues. So let's say a question of interpreting the standard of treatment in the treaty in dispute. They could also be factual disputes. So if we look at the Cyprus case, one of the issues in that case is whether the deposit haircut that was imposed by Cyprus amounted to an expropriation or not. And that could be a case, that could be a fact issue that has a common denominator across claims brought by multiple investors. And perhaps that's something that could be heard together. Now, again, there's nothing unique about clubbing together issues and hearing together when they have a common thread running through them. Let's take an example of the usual multi-party arbitration that we see. A usual multi-party arbitration would be an arbitration that's been started by a local company established in the host state, along with its foreign-controlled investor. Both of those claimants have distinct rights of their own, but when they bring their claim in a multi-party setting, they heard together, the issues are grouped together. So, nothing unique about group examination of issues, nothing that should force us to think of mass arbitrations as a unique creature. And in fact, this was one of those rare points on which Arbitration majority and the dissenting arbitrator Abhisab agreed. Just a quote from Mr. Abhisab: "The procedural right of respondents does not necessarily preempt any and all group examination of claims. For as long as the mass claims are cast into one claim or are identical claims, the tribunal can examine adversarially all the aspects and components of this one claim, in spite of the multitude of claimants." That then brings me to my third and last example of a technique that's been used in mass claims, and this comes from the Cyprus case. In that case, the respondents' concerns about managing the arbitration because of the complexity of a mass claim all boil down to the fact that the proceedings would take far longer than an ordinary arbitration would take, and the usual steps that one sees in an arbitration that's included in the procedural timetable would be far more complicated. And as examples, it emphasized that the discovery process in the case would be extremely complicated because you'd need documents from the 700 odd claimants in the case. And the hearings would go on for 60 odd weeks, which is far longer than the 1 or 2 weeks that it takes to hear an ordinary investment treaty arbitration. That's fair enough. These cases are more complex. The procedures might take longer to complete, but that again, by itself, doesn't change the procedural framework within which arbitrations are conducted. So all of this to basically say that the kind of procedural techniques that have been used and are likely to be used going forward in mass claims are not procedural techniques that we haven't seen before. They're not procedural techniques that are not employed in traditional arbitration. So it shouldn't give us any reason to treat mass claims as, in its nature, as a different kind of arbitration, different not just from a two-party arbitration, but different from the broader spectrum of multi-party arbitration. So then, to just sum up this first half of my presentation, there's always a superficial appeal to terminology. But in this case, using the terminology of a mass claims, insinuating that it somehow is linked to a class claim, does disservice to the issues really at hand, because mass claims is merely just a descriptive reminder of the number of claimants in the dispute. It takes away from what is precisely the core concern over here, which is, can multiple claimants bring a claim against another state? And would that situation give rise to questions of jurisdiction, which I'll turn to in the next half of my presentation. But this last point, I couldn't have said better than what has been said in the recent decision in the Cyprus case, and I've put that up for you, where the tribunal said that it does not see any consequence flowing from the use of the term mass claims to describe the case. It's simply used as a convenient shorthand expression, and the real questions of jurisdiction and admissibility are to be decided based on the substantive nature of the claims brought before the tribunal. That concludes the first half of my presentation. I'll pause here and invite any questions or comments that you may have.
Thank you so much. Dr. Kabra, for your wonderful presentation. I have taken the liberty of muting some of the participants. So if you cannot speak, just write your question, and my apologies for that. So do we have any questions? It seems, okay, here is one question. It says, would not granting joinder or permitting mass claim of foreign investors to challenge a developing state public policy, for example, tobacco companies against a public policy, a public health policy, prolong the dispute indefinitely and restrict the state's regulatory power? We cannot hear you, it seems.
Thank you for that question. On the first half of that question, which is whether the dispute would be prolonged indefinitely, well, that's a challenge with arbitration. Proceedings takes long, but that shouldn't take away from the rights of an investor to bring the claim. So long as the treaty gives the investor the right, the investor is at complete liberty for exercising that right, even though it might just prolong the dispute indefinitely. And on the second half of the question, whether it restricts the state regulatory power, I think that goes to more the merits of the dispute, whether the exercise of that regulatory power necessarily breaches the investor's rights as given to it under the treaty. But it shouldn't, again, affect the ability of the investors to bring the claim in the first place.
Perfect. Thank you so much, Dr. Kabra. I hope that answers the question. So here's another question. Iran USCT case involved, which involved an assignment of legal standing to bring the claim, but not beneficial interest in the proceeds by 100% or more than, 100 shareholders of an purported company to 2 or 3 of their fellow shareholders to avoid a mass claim. Do you think this could work and simplify the dispute in the investment treaty arbitration context?
Well, it would boil down to whether assignment of a right is permissible in investment treaty arbitration, would it not? Because at the end of the day, if the rights are assigned, you would still need to prove that you're an investor holding an investment that is entitled to the rights in the treaty. And if you can't meet those grounds, then the tribunal wouldn't have jurisdiction to decide your case.
Perfect. Thank you so much, Dr. Kabra. I hope that answers the question. Do we have any more questions? Or shall we move to the second part? It seems we don't have more questions. Should we proceed to the second part? And if there are any more questions, we can probably address them at the end.
Sure. So then just picking up where I left, which is whether these multi-party arbitrations raise questions of jurisdiction. Unlike in the first part of my presentation, here I do not propose to leave you with any answers. Instead, I want to leave you with some food for thought. Let me just start this section by giving you a moment to consider a quote from Arbitration that I'm about to put up. So paras 490 and 492 of the decision from Arbitration, in that case, the tribunal basically asked the question whether in a situation where it has jurisdiction over each one of the claimants that have banded together, would it lose jurisdiction just by the mere fact that they've banded together? And it said that the mass aspect of the present proceedings don't raise the question of whether the respondent consented to exit arbitration. They raise the question of the modalities and implementation of the exit proceedings. I'll leave that on for a second. So these two paragraphs from Arbitrat have bothered me for several years now. And we can debate about whether the way Arbitrat phrased the issue is the right way to phrase it. But I think there's something there in asking whether we've been right so far to assume that multi-party arbitration implicates a question of state consent. This is unfortunately a question that the tribunals that have followed Arbitrat have refused to answer. And again, I'll just share a quote from the recent decision in the Cyprus case, where the tribunal tells us that it's aware of the differences in views over the relationship between jurisdiction and admissibility, but it does not find it necessary to take a position on this matter in order to reach its decision. It then goes on to decide the question both under the rubric of jurisdiction and under the rubric of admissibility. So let's look at what a typical consent provision looks like in a BIT. A typical consent provision in a BIT will include several conditions to consent. The first condition would be that the claim must be brought by a person who qualifies as an investor under the treaty, so whether the tribunal has personal jurisdiction or not. The second question would be whether the claim relates to an investment as defined under the treaty, the question of the tribunal's material jurisdiction. The treaty will then impose some geographical or temporal limitations. And finally, the treaty might also impose certain other conditions to consent. For example, that the investor must negotiate before starting the arbitration, or it must spend some time litigating the issue in local courts. Now, none of the conditions that I've just flagged for you say that a state has limited an investor's ability to bring a case individually against that state without combining its claims with other investors. Why then are we casting this entire issue as an issue of consent? Let me throw in an idea over here. Probably the reason we're casting this issue as an issue of consent is for pragmatic reasons. And Jen, just to elaborate on this point, let's look back at the multi-party arbitrations that we've seen in investment treaty arbitration. You'll find it interesting that statistically, at least, 1 in every 3 arbitrations is a multi-party arbitration. But we don't see such challenges being raised in each one of those multi-party arbitrations. Now, pre-Arbitrat, the kind of multi-party arbitrations that we saw most frequently, in fact, almost always, were multi-party arbitrations that arose from a single investment operation. Let me just give you brief examples of that. One that I'd mentioned earlier in my presentation was a claim brought by a local subsidiary established in the host state and the shareholder of that local subsidiary established in the home state. The shareholder and its local subsidiary joined together to bring a claim against the state on account of measures that the state has taken against that local subsidiary. That's a fairly common type of multi-party arbitration that we see. There are other variations of this precise kind of multi-party arbitration. You might have cases where there are multiple shareholders in a local subsidiary, and these multiple shareholders join together to bring a claim against the state. But even those claims relate to a measure that has been taken against the investment operation. So there was a very high level of similarity, one would say identity between the claims that were being brought in these multi-party arbitrations. So nobody really batted an eye. But after Arbitrat, we're seeing cases where there are investors who each hold distinct investments and they decide to join together because the state has taken a measure against those investments. And this is where the pragmatic concern arises. Let me give you 2 hypothetical examples and see where the concern arises. In the first example, let's just assume all of us are citizens of Utopia who all hold land in Ruritania. Ruritania, for some reason, doesn't like Utopia and decides that it's going to take away all of the land that we hold. Together, as investors holding land in Ruritania, whose investment has been expropriated, we might decide to bring a claim together. Now, again, instinctively, that might not really bother you because there's a significant similarity between the claims that have been brought. Let's take another example where again we're all citizens of utopia having invested in Ruritania. In this case, let's say my investment in Ruritania is a land holding. Your investment is setting up some manufacturing units. And for those investments, what Ruritania has done is it's imposed extremely high level of taxes that are expropriatory in nature. Let's say another third set of you all hold concessions in oil and gas projects in Ruritania, and those concessions have been expropriated by another measure that Ruritania has taken. Now, at its core, Ruritania is going against all of us citizens of utopia. But would you instinctively think that our claims should be joined together? Perhaps not, because our claims are based on different state measures, um, raising different factual and legal concerns. And this is really where the pragmatic concern lies, because once we're in a realm where there are multi party arbitrations being commenced by investors holding distinct investments, we need to draw a line between what's acceptable and what's not acceptable. To address these pragmatic concerns, tribunals have so far tried to mold the concern into one of consent. And I'm now going to make two remarks for why casting this as an issue of consent might be problematic. The first one is a slightly more conceptual concern and goes to the question of arbitration without privity. Now, Jan Paulsen had famously described treaty arbitration as arbitration without privity, excuse me. And that very basic point has a significant role to play in our discussion. Again, let me just digress briefly with an analogy from commercial arbitration. Let's take a multi party arbitration started by multiple consumers against a seller, Apple maybe. For each of those consumers, they would have entered into a different contract with the seller. Each of those contracts would have a different arbitration agreement. To overcome the privity of those contracts and start a multi party arbitration in that situation would require some indication that the parties consented to combining the different arbitration agreements in that way. But that same problem simply doesn't exist in investment treaty arbitration because it's an arbitration without privity. You have an open ended offer from the state. When that open ended offer is accepted by a bunch of investors, when they file their notice of dispute, the state ends up in a relation of privity with all of those investors. So, unless one can point to a condition in that offer that has been extended by a state for arbitration, there's no reason to say that that privity cannot be established between a group of investors and a state. And just to perhaps drill that point home, this distinction is most evident when you compare multi party arbitration in the way I have defined it with consolidation of arbitrations. Consolidation of arbitration occurs when you have separately instituted arbitrations that are then, after the commencement of those different arbitrations, joined together. Now, when consolidation occurs, what happens is each of those investors that started the distinct proceeding enters into a relation of privity separately with the state. And precisely because you have to overcome these limits of privity, do you need consent, specific consent to consolidation in the case of investment treaty arbitration. But that again does not simply apply to multi party arbitrations. So that's the first sort of conceptual problem that I have with casting this issue as one of consent. Let me now move to looking at what tribunals have done and the reasons they have offered in trying to analyze this matter as one of consent. And here, with due respect to all of the eminent arbitrators that has given us these decisions, None have managed to offer us a coherent analysis that can withstand scrutiny. What I'm going to do now is put a few examples up from decisions where consent has been found for multi party arbitration. And then I'm going to look at some of the dissenting opinions that questioned the existence of consent for such multi party arbitrations. Let's look at let's look at the decisions itself which upheld consent. To keep within the time, I'm going to try and take three examples here. The first of which is a decision in Ambiente Oficio v. Argentina, where a case was brought by over 100 investors against Argentina, arising from the same facts as Arbitration. Now, in that case, the tribunal first began by looking at whether there existed consent to multi party arbitration per se on a principled level. And it ended up giving us 7 reasons for why consent existed. I've just put forward 3 reasons for you over here from paragraphs 135, 136, and 144. If you just look at those reasons, the first set of reasons are to find consent, that the history of ICSID is replete with examples of multi party arbitration, and in none of those instances have a jurisdictional concern arisen. Well, that's all well and good, but that doesn't really tell us how the precise treaty in that case from where the consent was derived should have been interpreted. Just the mere fact that previous tribunals had not suo motu considered this as an issue of jurisdiction is neither here nor there. The second or the seventh reason in this that the tribunal offered was slightly more policy-based reason. It told us that where a BIT covers investments that are susceptible of involving a high number of investors, so sovereign bonds, for examples, the state party must have assumed that a large number of claims would be brought against it, and those claims would be brought in a multi party setting. Now, again, we know how a treaty should be interpreted, and these policy based considerations cannot be used to interpret a treaty. That's on the existence of consent side. Let's now look at what the tribunal had to do to deal with the pragmatic concern that I flagged for you, which is where does one draw the line when there's a multi party claim being brought by investors holding different investments? And on that, the tribunal said at paragraph 153 that it has doubts whether completely unrelated claims could be brought by a plurality of persons in one and the same proceeding. The tribunal's doubt is a legitimate one, but that doubt cannot inform how the treaty should be interpreted. That's how Ambiente Oficio chose to deal with the issue. Let's now turn to another decision, Alemani v. Argentina. Again, arising from the same facts as Argentina, involving over 100 investors. Here, the tribunal, let me just foreshadow the issue over here. There's a pedantic question that arises in each of these multi party arbitrations because the way the treaties are drafted says that an arbitration can be commenced by an investor against a state. So, an investor in the singular against a state in the singular. Respondent states have latched on to that phraseology to say the use of the singular term means that there was no consent to multi party arbitration. Addressing that very point, the Alemani Tribunal tells us that the principles of treaty interpretation set out in the Vienna Convention don't impose this form of lexicographical literalism on terms. We all know that the singular can mean the plural and vice versa. And therefore, just the fact that treaties use an investor doesn't suggest that the state had conditioned its consent to arbitration with just one investor and not multiple. But then, when it had to address this pragmatic concern of where to draw the line, it had to fall back on the use of the singular and the plural terms. And in this case, Alemani told us that the state had consented to arbitrate the a dispute in the singular because that's how the treaty phrased it. So one had to look at whether there was a single dispute in issue or whether there were multiple disputes in issue. If there were multiple disputes in issue, then the state had not given its consent. Well, you can't use the same reason to defend one position and decline the other, but unfortunately, Alemani had to do that to address the pragmatic concern. Let's now look at the Cyprus case, and I apologize for the typo on the slide there. The case is against Cyprus and not Argentina. That tribunal took this logic forward that Alemani had put forward. And again, when talking about whether the tribunal had jurisdiction to decide multi-party arbitration on a principal level, it looked to the phraseology of the terms, whether they were drafted in the singular or the plural. And it said that in that case, the treaty in dispute used the term, there were two treaties in this case. One used the term any dispute, the other used the term any investment dispute. And this to the tribunal meant that more than one dispute could be brought against a contracting party. Great, so we have jurisdiction over multi party arbitration. But now we need to rein in that jurisdiction and limit it to claims that have some degree of similarity. So, what does the tribunal do? It turns back to what the Alemani said, and it says that it agrees with the Alemani tribunal that there must be a dispute within the meaning of the relevant BITs and not a myriad of separate disputes. So, just a few paragraphs down in its reasoning, it contradicts itself and says, well, actually, while I earlier said that the treaties allow multiple disputes, they don't really. One needs to look for a single dispute. I can give you examples from other cases as well, but I'll pause over there. This just goes to show the struggles that tribunals have had in trying to find consent to multi-party arbitration in order to uphold their jurisdiction to hear these claims. Let me just take a couple of minutes to now talk about the dissenting opinions. The dissenting opinions that we've seen come out on this issue have often latched on to that very pedantic point that I told you. They say that the state has consented to arbitration with a singular investor regarding a singular investment, and therefore, unless some other form of consent can be found, one must agree that the tribunal doesn't have jurisdiction over these disputes. But then, when these dissenting opinions were faced with the question, well, you've had these treaties, you've had 1 in 3 arbitrations being multi party arbitration despite the language in the treaties, what should we do about that? So it starts carving out exceptions to the basic principle it sets out. The first exception it gives us is an affiliation exception. So the multi party arbitrations that we've seen so very commonly are in arbitrations that are brought by affiliated investors in relation to the single investment arbitration that I just told you about a few minutes ago. And because they're brought by these affiliated investors, they're actually principally claims brought by one investor relating to one investment. Now, that logic is sound in policy, but it's not sound in interpretation. And to just make one point on that, let's look at other aspects in which this question has come up. Let's look at a question where we're talking about claims being brought by shareholders and claims being brought by local subsidiaries. In that set of cases, we've often heard that claims brought by shareholders are distinct from claims brought by the local subsidiary, and we've often heard that the Barcelona attractions principle doesn't apply. So you have on one hand tribunals drawing distinctions between investors and their investments based precisely on their identity and the nature of the investments they've made. But then again, when we read these dissenting opinions, we're trying to transcend those very distinctions and fudge them into one investor and one investment. It's playing your hand on both sides and it simply doesn't work. The second exception that these dissenting opinions have offered us is to tell us that in all of these cases, The respondent didn't raise any jurisdiction. And because it didn't raise any jurisdiction, it gave its consent to these kinds of arbitration. Now, those of us general international lawyers over here will recognize that argument to sound as somewhat of a forum prorogatum, an argument that when a state doesn't raise an objection to jurisdiction, it has consented to jurisdiction. And you'll see that quoted in the ICJ statute and its rules. And that argument works again for a standing institutional body like the ICJ, where it's a standing court with jurisdiction, but it doesn't work for ad hoc tribunals who derive their very jurisdiction from the consent of the states. If the states have consented to a limited set of circumstances, and that is the precise consent which forms the arbitration agreement, then it's not up to the state to then subsequently amend that arbitration agreement unilaterally, because the other state is not a party to the dispute, and extend the tribunal's jurisdiction to cover multi-party arbitration. You either have jurisdiction under the terms of the treaty or you don't. You cannot have forum prorogatum. So those are my two problems with trying to mold this issue into one of consent. As I said, I don't have any answers for you. I absolutely appreciate that this is a pragmatic concern that needs to be addressed. So what I want to end my presentation here with is a question. Given that we have this very legitimate concern regarding multi-party arbitrations of this sort, and given that treaty interpretation doesn't give us a very robust solution, are we better off casting this issue as one of admissibility? And with that question, I want to end this discussion and invite your questions.
Thank you so much, Dr. Kabra, for your thoughtful and insightful presentation. So now we could have some questions if the participants have any. You could go ahead and speak if you would like, or you could just write your comment and I could see it here and I'll read it.
Before I get a question, I can see Michael Weibel has graciously joined this discussion, and I wanted to take a moment to thank him for his presence here and for supervising much of what I've spoken about today.
Well, Professor Weibel is also the godfather of the Cambridge Arbitration Society and helped us during the first and early stages of the CUArb establishment. So we'd like to thank him as well. Do we have any more questions? It doesn't seem that we have any questions, so we can wait for a bit. If you would like to add, here is Professor Weibel. Maybe you could probably say a word or two.
Well, thank you, everyone, and thank you in particular to Dr. Kabra for her presentation, which I very much enjoyed seeing where her work has come since she has completed her PhD. And delighted to see the society flourish, even during those times when only online events are possible. So thank you very much for organizing.
Thank you so much, Professor Weibel. It seems that we have a question here. It says, I wonder more broadly whether you think we will see a rise in the number of mass claims in the field of personal data and big tech firms. That's an interesting question.
Indeed is. Thanks for that question, Emilia. I think we're moving towards a world where we're definitely going to see more multi-party actions. We've seen that in the domestic setting. The Merrick decision in the UK had come out very recently. So we're definitely moving towards a world where there'll be more such claims. Whether personal data and big tech firms will be the the field that will push it to that end. I'm not sure, perhaps.
Perfect. Thank you so much, Dr. Kabra. Do we have any more questions? Well, it seems we don't have any more questions, so I would leave it to you, Dr. Kabra, to conclude, probably, or maybe if a question or two are raised, you can probably address them during your conclusion.
Absolutely. Well, thank you so much, everyone, again, for your time. And if any question or comment does come to your mind, please do email me, and I'll be happy to take this offline.
Thank you so much. Thank you so much, Dr. Kabra, again, for joining us, and thank you for your insightful and thoughtful remarks. And I would like to invite everyone again to join our social media platforms for future events and lectures. And we hope to see you again. So thank you so much, everyone. Thank you, Dr. Kabra, again.
Thank you, Ibrahim, and thank you to the Society.